Good evening, Texas AFT members. My name is Zeph Capo. I'm the president of the Texas AFT, and we welcome you to this evening's Know Your Rights session. I want to say hello to everyone out there who's watching, in addition to our members. Thank you to fellow educators that could be tuning in, as well as our friends of public education. I'd like to start off by introducing the members of our panel this evening. Joining me tonight will be, first of all, Martha Owen, our General Counsel for the Texas AFT. As well, Patty Quincy, Legislative Counsel for the Texas AFT, and Jamie Womack Williams, the Director of Professional Development for the Linda Bridges Institute with the Texas AFT. I'd like to go over our agenda for today. If we could start that PowerPoint. The first part of today's Know Your Rights training, we will talk about your right to organize and your right to build collective power. We will touch base on what we spoke about last month, which is the Family Medical Leave Act and ADA accommodations that you may potentially utilize during this time with COVID. We'll also talk about whistleblower protections for public and school employees who are going through the COVID crisis on our campuses. In addition, statutory rights that you have as public educators during normal times. Once we've gone through these periods, we'll have an opportunity to stop and take some question and answers before we then break into part two. In part two of our session tonight, we're going to go deeper into detail on your First Amendment rights as public education employees. We will talk about speech as a public employee and how it relates to your workplace, how to engage in social media and other digital platforms as a public education employee and in the context of your First Amendment rights. There's been a lot of questions about striking in Texas, and we will certainly talk about that and other work actions as they impact you as public education employees. And again, we will have an opportunity then to take questions and answers from the group. So what I'd like to start off with, next page in the slide, please, is your right to join a union. As a public employee, you have the right to join or not join a labor organization. You have the right to have your to paycheck deduction. One of the fundamental rights to start your membership with the union. That's been a controversial issue over the last several years with the legislature as the forces that work against you have tried to curtail that. We are working hard on that, and we've worked hard to make sure that your rights are not curtailed, but we also have put systems in place because we want to be prepared. I fully recommend each of you join by bank draft. It's time that we own our power. It's time that we not allow others to have leverage over us. Having a direct relationship with your organization through bank draft and our eDo system is a way to take that power away from those who would rather control you in a way that is not in your best interest. I want to talk a little bit as well too, because throughout a lot of this process, we've seen many of our colleagues out there who either aren't familiar with the fact that we do have unions in Texas or aren't familiar with what those processes are, to really give some context around that, because what we can't do is we can't allow those who say no or those naysayers that say you shouldn't join an organization to stand in our way. And I want to put some context around that. Margaret Haley is considered the matriarch of our union. She was a teacher in Chicago public schools back in the days when teachers, particularly female teachers, were paid less than men, when they had different rights, when they had no rights, when they were required to live in the homes of their students, when they were required to be single and not married. She joined the union in 1898. In 1916, she helped form the American Federation of Teachers. In 1937, the CTU was formed, the Chicago Teachers Union, and it was 1967 before the Chicago Teachers Union won their first contract, actually got to collectively bargain. I want you to take a look at that time frame. I want you to take a look at the work that it took to get them where they are. We started our union in Texas in the 1970s. We are leaps and bounds ahead of where they were when they were in their process. The only thing that we have to fear is fear itself. The only thing that we have to do is not let the naysayers out there keep us from building power, keep us from building our voice together as educators to advocate for the best interest of our members and the best interest of our students. That's why this is important, because you never know when a COVID crisis is going to come. You never know when you're going to face the things that we're expected to face this August as compared to last August, because it's not the same as it was before. This year is not going to look like it did last year or many of the years before whenever you return to school. And fortunately, we have long-standing unions that have been in place. If you talk about and look at the collective actions, one of our rights under free speech and free speech and the First Amendment is our right to contest actions that we don't believe in, our right to be engaged in public policy. And where we have strong locals, we've seen the most progress across the state of Texas. Look at some of the actions that we've been engaged in around COVID. Unionized members, non-unionized members, others coming together to build their voice by sending letters, by engaging in car caravans, by going through the protest process, by speaking to the board. When we bring our voice together, when we have that larger voice, we're able to make more happen. We're able to build the power that we need to see change. And as Frederick Douglass reminds us, if you remember his words, probably one of his most famous quotes, power concedes nothing without demand. It never has, and it never will. And until we develop a strong enough voice to be able to build the power around to put our demands in action, we will not be able to get the concessions that we're looking for. And it's not like we're asking for anything that we don't deserve. Every single one of our members out there deserve a safe workplace. Every single one of our members deserve the ability to be able to go in every day and not be concerned that they're going to get sick or they're going to bring a virus home to their family. Every one of our members deserve to go to work each and every day and not worry about if any of the students that they're in charge of are going to get sick because the processes weren't followed, because there wasn't enough protective equipment in place. These are the things we're fighting for. This is the reason that we're here today. And I want to thank you for participating with us today in this Know Your Rights session. I want to talk about some of the collective action works. There's no coincidence that where we've had the strongest, most engaged unions, we've also had the best developed reopening plans that have safety at the core of those plans. Where we have those strong unions, we have members that are educated on the rights and educated on the processes. They're actually sitting at the table to help develop these plans. They're part of the decision-making process. And when our members are able to be part of the decision-making process, then we end up with plans that could put staff and students at the core of the mission. We're very proud of our locals that have been engaging in this process and then standing up where they have to try to make things safer for our members. And we're going to continue to do that as a union on the local level and on the statewide level. So at this time, I'd like to turn the stage over to our General Counsel, Martha Owens, so that she may give us a reminder of what we talked about last month with the family medical leave, with the ADA accommodations and others. Martha.
Hi, everybody. Thanks for attending this webinar. I'm going to make a shift from what Zeph talked about in terms of the agenda. We had so many things to cover today. The ADA accommodations piece it was really too much to talk about today. And we've done a webinar on that where that's available from the Texas AFT website. So I thought we would talk a little bit about a couple of different laws, and that'll allow us to time to also talk about the Whistleblower Act. So I wanted to talk first about two provisions in the federal law that Congress passed in March, the Families First Corona Response Act, or FFCRA. There are a number of aspects about it, but we're getting a lot of questions on these two particular provisions. So let me touch on those. The first is an expansion of the Family Medical Leave Act. And and I'll talk about the expansion piece in just a second, but just to kind of review, I know many of you are familiar with the basic provisions of the FMLA, but just in case for those on the webinar who are not, the FMLA provides 12 weeks of unpaid leave if an employee needs to take time off to care for herself or her family. And this would include reasons related to COVID-19. You have to have worked for the district for a certain number of hours, 1,250 hours over the preceding 12-month period in order to qualify. But assuming that you qualify, if you have a serious medical condition that renders you unable to perform the essential functions of your job, or to care for a family member who has a serious medical condition, that leave is available. So I mention this because plain old FMLA may be an option for you if you need to take time off. For example, if for those of you who may have serious underlying medical conditions, and if you've asked for an accommodation from your district and you have not, for one reason or another, received the accommodation that you have requested, for example, to teach remotely, and you try to work that out with the district, but that is not going to happen for one reason or another. Taking FMLA for that serious medical condition may be an option for you. Now, keep in mind, it's unpaid. The district, if you have leave, paid leave in your various leave banks, the district can make you take that paid leave first, and you may want to take the paid leave because obviously it's paid. But the entitlement that you get under the federal law is unpaid. So obviously that's a big disadvantage. But there are two very distinct advantages to FMLA that may help you out if you are facing a situation where you are thinking about leaving your job because of the challenges that we're facing because of COVID-19. Think about taking FMLA. It may give you enough leave, off from the particular situation we're facing with the pandemic, that we get past that critical time, hopefully, and before you have to come back from work. And during the time that you are off, you are entitled to continue your health insurance on the same basis that you have it now with the district. And when you're ready to return after your leave is up, then the district has the obligation under federal law to place you in a substantially equivalent position to the position you had when you left. So those are, FMLA, just the plain old FMLA is definitely an option for people to consider. Okay. Then let's talk about the expanded FMLA. That is FMLA this is what they did under the Family First Coronavirus Response Act. And that allows you it expands the reason so that you can take the FMLA if your child's school or child care, your daycare or child care provider is not available due to COVID-19 related reasons. For example, your daycare has closed because of the pandemic. So this is, you can qualify for the FMLA under those circumstances when ordinarily you would not be able to for that reason. So it's basically, and it's at least partially paid. It's basically a version of parental leave like we have never had in the United States before. And it's partially paid. The first 2 weeks, let's say you had the 12 weeks of FMLA available to you, the entire 12 weeks. The first 2 weeks of that is unpaid. You can take the emergency sick leave that I'm going to talk about in just a second. You can take that for the first 2 weeks, and then you go into this paid leave situation where it pays up to 2/3 of your salary, up to $200 a day. So that continues for the whole, the remaining 10-week allotment. So again, that partially paid FMLA is only available if you are taking it for the reason that I've described, where your child's school is closed or their daycare is closed due to COVID-19. And another kind of important caveat is this, what I'm talking about is an expanded reason to take the FMLA. It does not give you another allotment of FMLA. So you just get your basic 12 weeks. Now, so, keep that in mind. Say you had to take off last spring, you had surgery and you took off 3 weeks. Well, you're only going to be, have 9 weeks available. So I just stress that because that's been a source of some confusion or questions that we've received. Okay, so let me now move to emergency sick leave. This is a provision that the government passed where it gives you 2 weeks or 80 hours of paid sick leave. It doesn't come off of your time. Instead, this is leave that they have to give you if you need to take off for a COVID-related reason. Okay, and so this would be, for example, if you've been exposed to COVID-19 at work or in your off hours and you've been advised by your doctor to self-quarantine. It would be available if you have symptoms of COVID-19 and you're seeking a medical diagnosis. It would include time spent waiting to be tested and waiting for the results, or if you're in self-quarantine upon a doctor's advice. So if you have had an exposure, you need to get your doctor to certify that the doctor has recommended that you take off from work because of the self-quarantine situation. So if the district makes telework available, well, then you're teleworking and you're not taking emergency sick leave. It would only be available to you in a telework situation as if you're ill with COVID-19 or a family member's ill and you need to take care of them. All right, and then the last thing I'm going to kind of pivot from all of the COVID-19 related stuff and talk about the Whistleblowers Act. The Whistleblowers Act is a state law that's been on the books for quite a while, and it prohibits retaliation against a public employee who reports a violation of law to an appropriate law enforcement agency. And I want to highlight 3 elements that are very important if you are thinking about you're in a situation where you may need to avail yourself of these rights. Under the law, a violation of law is defined as a federal or state statute, an ordinance, or a rule that has been enacted, like by TEA, a commissioner's rule, pursuant to a state statute. So let me put it another way. A violation of law is not a violation of policy. A violation of policy does not, if that's what you're reporting, that will not entitle you to whistleblower protection. It's not considered a protected activity. Also, the report needs to be made to an appropriate law enforcement authority that is not just reporting the violation of law up your chain of command in a school district. Instead, it's got to be an authority outside of the school district. So, and the law says that the entity has to be actually responsible for regulating or enforcing the law. So generally speaking, in a school district setting, that's going to be TEA, or if it's some kind of criminal activity, it could be the district attorney or the police or the sheriff. And the third thing I want to mention is this is an anti-retaliation provision to show that the report triggered the adverse employment action that you're experiencing. The district needs to know you made the report. Otherwise, you're not going to be able to connect your report and the adverse action taken against you. So those are three particular issues that come up a lot when people are trying to seek the protection of the Whistleblower Act. So I think that's all my time, and I will pass it along. Thank you very much.
Our next speaker is Patty Quincy.
No, our next speaker is Jamie Womack-Williams, actually.
Oh, sorry.
Okay, I had Patty down too. Okay.
Oh, I'm sorry.
I'm going to talk to you a little bit.
Well, actually,
that's okay.
I'm sorry. It was kind of a quick. Just wanted to remind everyone that after Jamie speaks about your additional rights, we are going to have some more discussion about your First Amendment rights and your protection as an employee, with a particular kind of focus on employees who are elected to serve in kind of elected positions within their union or within their campus. So stay tuned for that. That's coming up in part 2. Sorry about that, Jamie.
That's okay. I'm going to talk to you about several issues as far as your job is related. The first thing we're going to talk about is contract abandonment. We are past the penalty-free resignation date, and there are things that you must consider before you resign and potentially get a mandatory 1-year suspension on your certification through the State Board of Educators certification. So number one, if you are feeling the need that you need to resign, call your local union representative before you ever resign. There are things that can happen, such as a negotiation with your school board to accept your resignation. There are some good cause reasons to resign mid-year, and some of those do include like a serious illness or a health condition of the educator or a close family member. And what we would do is we would just provide documentation of that illness or that injury or the change in your family's needs before you ever resign. Remember that don't take your administrator's word for it that you can resign mid-year. Only the school board can release you from your contract. The next thing we're going to talk about is planning and prep. Each classroom teacher is entitled to at least 450 minutes within a 2-week period or 10 days. Planning and preparation period under the section of the law may not be less than 45 minutes within the instructional day. So basically what that means is that you can't be given 15 here, 15 here, and 15 here. It has to be one 45-minute block. During the planning and preparation period, a classroom teacher cannot be required to participate in any other activity. The Attorney General of Texas has ruled on this and says that the planning and preparation period is for planning and preparation, and it is unlawful to mandate teachers' attendance at group sessions, ARD IEP meetings, PLC, grade level meetings. If you attend any of those during your planning and prep time, you must go voluntarily to those meetings. If you receive more than 450 minutes in those 10 days, your administrator does have the right to take some of your planning and prep time. For instance, if you receive 50 minutes a day, that's 500 minutes over the 2-week period. So your administrator would be able to take one of your planning prep periods to mandate you to go to a PLC grade level meeting or an ARD IEP meeting. So just look at the number of minutes that you're receiving and determine if they can lawfully take any of that time. We also, on our Texas AFT website, there are several links to case laws regarding planning and prep. The next item is your duty-free lunch. Each classroom teacher and full-time librarian is entitled to at least a 30-minute lunch period free from all of your duties and responsibilities connected to the instruction and supervision of students. If there is a personnel shortage, extreme economic conditions, or unforeseen circumstance, they can legally take one of your lunch breaks each week. Again, if that is happening to you, please contact your local union representative for more assistance with that. The next thing is about lost or stolen student-issued instructional textbooks or technology. The Board of Trustees of a school district cannot hold you legally liable to pay for instructional technology or textbooks that have been lost, stolen, misplaced, or damaged by a student. That includes textbooks, calculators, tablets, laptops, any of those things that your district is issuing to students. The only stipulation that they ask is that school employees act in good faith to maintain these items, such as if a student does report that something has been stolen, misplaced, or damaged, that you report that immediately to the district. The next item is documentation in your signature. You may be faced at some time with a written reprimand and that you don't agree with. Go ahead and sign it. If you fail to sign a written reprimand or a memo, it could potentially result in another reprimand for insubordination. Sign it and make sure that where you sign it next to your name, it states something like, my signature indicates that I have received a copy of this, but does not indicate that I agree with the content. Public information in your personal electronic devices. School employees must maintain text and emails received on their personal devices that include your cell phones, personal tablets, personal computers, that is related to district business. Public information held on your private devices or in a private account must be released within 10 days upon a request being made to you for that information. Employees have to maintain these documents received on their personal devices during their tenure and even after you leave that district. If you fail to provide the documents that are being requested, it could result in criminal charges against you. So just a little word of advice, don't use your personal cell phones, your personal email to communicate about district business. There are several things out there that you can access for free, like a Google Voice number that you can just download the app to your phone and it assigns you a phone number. You can text parents, students, and all of that can be tracked. It's easy to go online, print all of those text messages out. Another app is Remind 101 that a lot of educators use to communicate with students and parents. Easy to go online, print out any communication. If you feel like you need to file a grievance, number one, contact your local union immediately if you think you have a grievance. Typically, all grievances must be filed within 15 business days and all appeals must be filed within 10 business days. However, check your board policy because some districts have additional steps in their grievance policy, but contact your union rep and we will help you walk you through that process. But also to note that in 2015, some districts could potentially exempt themselves from specific state requirements if they became a district of innovation. So if you teach in a district that is considered a district of innovation, please check your district's policy to see which one of these things they may have exempt themselves from. And now I'm going to turn it back over to Zeph for questions and answers.
Thank you, Jamie. And I know that some of those rights that you've talked about were longstanding rights that happened before COVID, but there may be new utilizations for them. For example, the lost textbooks and electronic equipment. We know that we're going to have some students coming back to the room. We know that we're going to have some students that are staying online. And the practicality will likely be many of the students that are back in person, teachers may well be in a place where they need to make sure that they have devices because they probably have to teach the kids in front of them the same way that they're teaching the kids online if their district has forced them to do both at one time. So will we be including any of these information in the documents for those that registered?
Yes, and also you can go to the Texas AFT website, texasaft.org/COVID, and you will find links to the PowerPoint presentation and all links to all of the issues I just talked about that explains them more in depth.
Great, thank you. So if we could bring up the full panel, we do have a few questions that have come through. And I want to start off with this first question, I think, to Martha. We have a question from Teresa in Conroe ISD. Do we actually have any specific rights with COVID? And I think that you talked about some of those, how they apply to COVID. But the second part of the question is also, do we have to abide by our contract as written?
Well, I mean, generally, yes, you need to abide by your contract as written. I'm not sure if this is a contract abandonment kind of question. In other words, are you able to resign from your contract now? That's an issue that Jamie talked about, where you need to try and work that out with the school district before you resign. And a number of times, the districts are going to have to be dealing with this a lot more than they ever have. It's just, unprecedented. And so, I don't know what the districts plan to do, if they are going to accept resignations for, if somebody's got a medical condition or concerns, if they're going to accept those resignations, or if they're going to try and hold the teachers to those contracts. But the starting point is to talk to your district and figure out where they're coming from, talk to the union, and to find out what your rights are. I hope that answered your question.
Thank you, Martha. The second question comes from Elizabeth at Northside ISD. Can we take personal days off from school without being reprimanded or pressured, especially during these difficult times?
Yes, you're entitled to take the personal time in general. There are some good commissioner decisions on that. I mean, the district does, have some authority. Like, for example, a district will typically prohibit teachers from taking time off around the testing, the testing, standardized testing. So they can have some rights to have some sort of, I guess you'd call it reasonable control. But your personal time is your time. And so again, start with making the request and probably, I guess, before you do that, talk to the union to see if the union rep anticipates any problem. Then make the request, see what they say, and we'll take it from there. But I mean, generally speaking, your time to take off is your time.
Thank you. We have another question. This is from a paraprofessional. And Diane is asking, what about paraprofessionals? Will we have to cover classes for absent teachers when there are no subs available? Is that legal?
There is some, flexibility for the district in terms of that. They are not supposed to put certified people in the classroom without, for significant periods of time. If they do that, they have to send a notice to the parents that they are being, taught by somebody who is not certified. So I would say in that situation, I mean, they're really not supposed to do it. The students are entitled to have a certified teacher. Having said that, I think the reality is that many districts do it. I think, it kind of needs to be a case-by-case evaluation. If it's like for one day or one period, that's one thing. If it's, something that's going to keep happening, or it's on a long-term basis, and by that I don't mean very long. I mean, more than just sort of an ad hoc basis, I would definitely contact the union, because the district's supposed to have a certified teacher in that classroom.
So we have a couple of really good questions up next. And I know that, Martha, we did the webinar on the ADA last month with some of the FMLA that you talked about today. And the question from our callers or from our viewers is, are they able to be utilized together? Can they utilize both of them, or is this they pick and choose?
The utilize together.
Can the FMLA and the ADA be combined? In other words,
well, they really they have different purposes. The ADA is supposed to keep you working. You're still working, but you have an accommodation for, like you're doing virtual teaching. You're still working. You're just not doing it from the classroom. The FMLA is the opposite. It's designed to give you time off when you're not able to do the work. Now, it is a common accommodation under the ADA, bear with me, for them to give you FMLA time off if all you were otherwise able to perform the job, and all that you need is a little bit of time off. Again, I mean, that's the normal situation. How that's going to play out in the COVID world, where there are a large number of people asking for accommodations and time off, and then that starts to touch on what would be considered a reasonable accommodation. Does it put an undue burden on the school district? But sometimes unpaid leave, I guess what I'm trying to communicate is, yes, sometimes unpaid leave, like you would get under the FMLA, could be considered a reasonable accommodation under the ADA.
Martha, for our practical purposes, we have several of our teachers who may be going under particular treatments. They may be asking for an ADA accommodation to be able to teach virtually, but they may need intermittent leave through FMLA to go to a chemo treatment every Friday at noon. I think that would be would that be like a practical example of where they should probably be applying for both?
Yes. Yes.
Okay. Okay. And our next question, and this is a good one, from Cedar Hill ISD, and I can absolutely understand why this question is being asked. Can I stage a district-wide sick out without legal consequences?
I think the answer to that is people have their leave available to use for lawful purposes. And if they feel like they cannot go to work given the circumstances that they're facing, then they're entitled to try and use that leave. So that's my answer to that question.
So we have a question from Gina and Gilmer ISD. Are teachers required to wear masks in the classroom? I'm pro-mask, but any whole group videos that my son's teacher sends me, I'm a teacher on FMLA, she's not wearing masks with the face-to-face kids. That's kind of scary.
Yeah, very. I would say that whether, that's an individual district enforcement decision, I would certainly take those concerns to the administration and relay them. I think that's obviously a valid and serious concern, and ask them what are they going to do to enforce any sort of mask requirement. But the mask is an individual school district decision.
Latanya from Duncanville ISD asked this following question. Are school districts required to provide PPE? Are school districts required to disclose if you've been exposed to COVID?
Yes, they're required to provide PPE. If they're not, then that's something that you need to let the union know about. Obviously, that's of grave grave concern. And the second question, tell me again.
Are they required to disclose if you've been exposed to COVID?
Yes.
So, and just as a matter of fact for our members, there is a list of, and we can find out for you if you need to talk to the union. The TEA did provide PPE to all school districts. They did use part of the $1.2 billion, about 200 million of it that they received from the federal government in March, to provide PPE for school districts. We know that's not going to be enough. We know that it's not going to last, but certainly you should be finding out how much they received and how much you should expect on campuses. Everybody should expect to have masks provided. Everybody should expect to have cleaning supplies provided. If they're not being provided to you, please let your union know as soon as possible. So we've got a question from Elizabeth Welch. Do we need to use Google Phone for union organizing? And I think this might have been in relation to the concern about school business being on your personal phone.
Patty or Jamie, y'all want to take that one?
Well, I'm going to step in, and the lawyers tell me if I'm off on this one. If your union business is your personal business, it is not school business and would not be considered in the type of business that must be maintained on your personal device that Jamie was talking about earlier. If you are doing union organizing with your organization and others, that is not subject, even though the topic may be people at your school, on your work site, at your bus barn. So that is not applicable. You may choose to use a Google phone number for those purposes to be able to keep your separate organizing work from your actual personal, but that's going to be a choice for you. You won't be subject to the same requirements to maintain that data as you would if you were, say, having conversations with the parents of your students or others on your phone. We would definitely recommend that you use a Google line with perhaps a different type of system, or better yet, request from your district that they provide you the tools to be able to make the contact to your parents as they're requesting and needing. Okay, this is an important question for folks that have students coming back with COVID. It comes from Rochelle. Rochelle wants to know, what are my rights if students refuse to wear a mask in the classroom?
I think that that's an issue. Again, you need to talk to your district and find out what the district's rules are and report that student.
And we have another question from the paraprofessional group, Rosemary and Cyfair. Why are admins or professional employees getting paid to quarantine, yet the paraprofessionals are not?
Well, I don't know. I mean, I think that's a fair question. I guess, the district may be, and, I think the union could help you kind of figure out, do a Public Information Act request, contact the district to find out what the rules are. And if, we've got a situation where they're giving additional leave to admin people that's not available to the paraprofessionals, I think that that's an issue to take to the school board, because that's an issue of basic fairness. And we all know that the people who are actually in the classroom need that, they need the paid leave more than administrators do, who have less contact, at least in most situations, are having less contact with students and parents than the people who are on the front lines.
Martha, under the Families First Act, minimally everyone has been given an additional 10 days of leave for exactly this reason. This would absolutely apply to our paraprofessionals, correct?
Oh, yes. Yes. The emergency sick leave applies to all employees, regardless of your job title.
Okay, we have an additional question from Will and Colleen ISD. Who regulates and ensures schools are maintaining social distancing, wearing masks, and checking temperatures?
Under the governor's orders and the attorney general's opinions, they have put that. A lot of the questions y'all are asking me, the politicians have put that in the hands of the local school officials as opposed to the health authorities. There's been a big clash, as you probably know, as to who's in charge. And unfortunately, in my opinion, the governor has preempted local health authorities and has put that in the hands of himself and the commissioner of education, and the result of that, and then they've kind of given it now to the school districts, and the whole thing has been geared to taking it away from the local health authorities who would otherwise control the situation.
Ladies and gentlemen, we've come to the end of our Q&A time for the part one of this series. I want to thank our panelists who've presented today and helped answer these questions, brought forth some of this great information. This is just the very beginning. This was our very general Know Your Rights section to kick this off. Part two, we're going to go deeper into your First Amendment rights, how you can interact in social media and stay on the right side of the law, what you're able to go over and share and on matters of public policy, and who really are those people that are in a special category able to make proper critiques and speak for others on matters of public policy. Stay tuned for part two as we talk about your First Amendment rights. And thank you for being part of our Know Your Rights and Responsibilities podcast as they're going to continue over these next several months.